Let's decode the legal criteria that distinguish employees from independent contractors. What's the ABC test and what's AB5 got to do with it?
The ABC test. This is the primary test used in California to determine if a worker is an employee or an independent contractor. Codified by AB5, a worker is presumed to be an employee unless the hiring entity can prove 3 specific conditions related to the worker's control, the nature of the work, and the worker's independent business status. But so here's the problem that happens. People are hired as independent contractors and paid a daily wage, but then they're required to be working for 15 hours a day. And if you count the daily wage over a period of a month, they're making well below the salary requirements. Yet they're not given lunches, they're not given breaks, they're not given insurance.
That seems unfair for sure.
So, I've seen it go both ways. A lot of times employers will not benefit. The contractor will benefit. If everything is proper as the legislature intended it, it should be a mutually beneficial relationship because the employer gets a very specific service and they don't have to have this person on payroll.
What advice would you give to employees?
I am a person of integrity. I don't want to screw over companies. I also don't want to screw over people. I think everyone should get what they're owed. So here's the advice I would give to all the employees is that make documented complaints. Whenever something bad happens, make a complaint because once you make a complaint, the employer has a duty to do something about it, to protect you. No matter how big or small it is, you should make a complaint and make it in writing. If people are experiencing a hostile work environment, it should be documented. And then the employer has a duty.
What's considered a hostile work environment?
Generally speaking, a place of employment doesn't have to be a sorority. Everyone doesn't have to be super nice to each other. But at the same time, if there's consistent hostile reactions, if a supervisor is hostile to employees, they are not properly managing them.
So would that be name calling? Would that be...
It can be name calling. It can be brushing them off. It can be excluding them from opportunities. All of these things could be hostile. But here's the thing. Even if it's something that's not illegal, once you make a complaint to HR is going to talk to the supervisor and just be like, hey, knock it off, right? And then you're protected from retaliation.
So the employee needs to go to HR department and make a written complaint.
Yes. Some companies are smaller. They don't have HR, but you do have to make the complaint to someone who is in a supervisory position. Some of the most difficult cases to prove are pregnancy discrimination cases because, as you know, when a woman is pregnant, a lot of times, you're more tired. You're a little bit slower. You're creating human life a lot of times, especially if you have morning sickness. You can't really operate like you would normally. And the problem is employers will write you up for performance when you're pregnant, and the performance issues may actually be related to your pregnancy and the employer isn't taking into account.
Does it matter if you told the employer you were pregnant versus you didn't?
Yes, because if the employer has no knowledge you're pregnant, you can't really prove that it's indiscrimination for your pregnancy.
Yeah, that makes sense.
But so I've had cases like that where employers will write women up, and then I've had 2 cases like this that when the woman tells the employer they're pregnant, they start writing them up. And I brought the claims, and the employer gave me emails or correspondence showing that, prior to the actual pregnancy, they had performance issues that weren't formally documented. Maybe they weren't written up, but there were internal emails showing that this was an issue. And those are very hard to prove. I actually had a case where a woman was 5 months pregnant, and she had a really high-risk pregnancy, so she didn't tell her employer until she was about 5 months in. And she, immediately after she told them she was pregnant, they started sending her written communications saying, you need to have your Zoom camera on during meetings. This is against company policy. You don't have your Zoom camera on during meetings. And she was like, this has never been an issue before, but all of a sudden I'm getting these documented write-ups for not having my Zoom camera on. One time her camera wasn't working, and the chief operating officer would send her these like very hostile texts, like turn your Zoom camera on, all caps, exclamation points. She was like, whoa, what is happening?
So
like
what
that.
happens if it was undocumented before the pregnancy? You said it's a difficult type of lawsuit and gets documented after. To me, it seems like once the employer is on notice, then, and if they haven't documented it before, then they would still be liable?
They would still be liable, but the problem is these cases just end up getting so drawn out. So for that particular case, we ended up filed in state court. It was removed to the federal court because the employer was in a different state and the employee was remote. And the federal judge was just like not having it. She was like, well, the employer has communications showing this was an issue before. Just because they started writing her up formally after she was pregnant doesn't mean anything. We ended up settling the case. We spent a ton of time on it. And even the judge was like, you're not going to be able to prove it.
I'm surprised that the pregnancy cases are more complicated. I thought they would be a lot easier.
They're more complicated because it's such a fine line between performance due to pregnancy versus your performance. Like if
you have to prove causation,
you have to prove that the adverse employment action, or whether it's a write-up or cut hours or a termination, is because of your pregnancy. Like the pregnancy, legally, the pregnancy has to be a substantial motivating factor in the employer's decision. So if they had prior write-ups, prior things, even if it got worse, you can't necessarily prove that the pregnancy was a substantial motivating factor. Was it a factor? Probably.
Wouldn't that apply to any disability? Because pregnancy is considered a disability. Would that apply if someone ended up having some other disability or illness and then they're not performing their job?
Yep. And I see this a lot also. The other place I see this oftentimes is mental health disabilities, such as anxiety, PTSD, even inability to sleep. Insomnia could be a disability if your doctor qualifies it as such. If you have, a lot of veterans we see coming back, they're trying to reintegrate into the workforce, they have really bad PTSD. They can't be around loud noises.
But how does it work? I know on another episode you said that as long as an employee reports it, the employer has a duty to accommodate.
Yes.
So let's say somebody reported it and the employer accommodated, but their performance is really terrible, interferes with business functions. How does that work in terms of a potential lawsuit when it ends up in your hands?
It's hard. It's hard, and you have to make the arguments on both sides, and I do. So that's the thing. So the process has to go. If a complaint is made that I have a disability or I'm unable to perform my functions, you have to provide from a physician a note stating what accommodations do you need specifically. And nowadays, everyone wants to come. Every employer is trying to get employees back into the office. So they want to know from the physician, not just they have to work from home, but like what accommodations do they need at home that I can't provide here on site. And a lot of employers are fighting hard to force people into office right now. Like it is a thing. So then they have to show that here are the accommodations that we can provide you so that you can continue to effectively perform the functions of your job with these accommodations.
So let's say if someone cannot drive, an employer can argue you can take an Uber, right?
Well, if they
pay for it.
The employer is not going to pay for an Uber if
Okay.
they can't drive. If they can't drive, if it's a temporary condition, maybe they might be able to do remote for a temporary time. As long as they're accommodating the conditions, if their performance still doesn't meet up to the expectations, they can then terminate them. As long as the employee can't argue, I wasn't accommodated. I'll say that even when claims happen, a lot of times employers will keep making the same mistakes again and again because every time there's a claim, they quietly settle it out before a lawsuit is filed.
I can see that applies to a lot of the sexual harassment cases you handle.
Oh, yeah.
Especially when it involves attorneys and people who are licensed or that have publicity.
Yeah. People with professional licenses don't want public lawsuits against them showing these things. So a lot of times employment lawsuits will settle.
But then some people stupidly do it again and again. They should learn from it, but they don't.
Yeah. Well, California does have this fee shifting provision that's in the law, and it incentivizes employment attorneys to take cases. And it basically says that if you're an employee and you bring a lawsuit, if you win on the lawsuit, even if your verdict is $1, you can get all of your attorney's fees and costs.
That's unfair.
It is unfair. It's very unfair for the
That is very
employers.
unfair.
But as a result, you know, you bring a claim, and even if it's a very low value claim, an employer has the incentive to settle and pay a little bit of a premium.
That's so stupid. Like, it's killing California business.
I agree. A lot of employers don't do business in California because of the cost of litigation.
I didn't even know that, but that sounds so ridiculous to me.
But so, like, you can bring, like, I don't do this because I have integrity, but sometimes plaintiffs' attorneys will throw everything at the wall and bring, you know, maybe there's one thing that was done wrong against this plaintiff, but they will make 1,000 claims like harassment, discrimination, retaliation, blah, 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 and make this huge lawsuit out of it, even though there's only liability on maybe one claim. But the employer, once they hire an attorney, the attorney's like, okay, you only have liability on one claim, but to litigate this, it's going to cost us $200,000. So even if your jury verdict at the end of the day is $25 in damages, you will owe that attorney $200,000 in fees.
I think it's best to pay an attorney to defend than have multiple lawsuits that are BS, because that just incentivizes people to bring frivolous claims.
But here's the problem. Maybe you did screw up somewhere. Maybe there's, like, sometimes it's worth it to settle. I see a lot of cases where, because there is vicarious liability on an employer through the actions of a supervisor, which means that if your supervisor screws up and does something illegal, the employer is automatically liable for that.
Right.
If the supervisor sees something illegal happening and fails to report it, the employer is automatically liable for that. So a lot of times you'll have situations where, like, the employer did nothing wrong, but the supervisor either failed to report or did something wrong, so the plaintiff will bring a claim, and it's worth paying rather than trying to F around and find out. You know?